Good morning, everybody, and welcome to our most recent webinar this Thursday morning. Today's webinar is about a topic of workplace investigations, and it's something that Louise and I decided to talk about because we both have quite a lot of experience, both acting as the role of investigator and going into organisations and doing investigations ourselves, as well as advising clients in relation to the investigation process. And so we decided that it would be nice to have a little bit of a break from COVID for this month and choose a non-COVID related topic and talk about workplace investigations, because what we've also found, I've personally found, is actually the number of investigations that clients are needing to do is increasing. Even though most people are still working from home, issues do still arise in the workplace that require investigating. So it is a live webinar, so do feel free to ask questions as we go along, and we will answer these, of course. And before I forget, at the end, when the event ends, there will be a page that pops up asking for feedback. And we'd be really appreciative if you're able to provide us with some feedback afterwards, please. So moving on to the agenda. So what we're going to do is we're going to split the webinar into two parts. So the first part is really looking at investigations in the workplace, which are employment related, which is obviously my field. And then and what I'm going to do is I'm going to look at, what is an investigation, why are they important, and then go into some practical tips into actually how to carry out the investigation. And also at the end of my bit, I'll also talk about some potential pitfalls and how to deal with them. And then I'll be passing over to Louise, who's going to talk to us about workplace accident investigations, and that being her area of speciality. So what we're going to do first of all is we'll move to my part. And I'm going to focus mainly on grievance or disciplinary investigations, because they are the most common areas where investigations are required. However, investigations may also be necessary in other situations. For example, potentially where there's been breakdown in working relationships, and you may be looking to potentially terminate an employee's employment on the grounds of some other substantial reason, or perhaps due to breakdown in trust and confidence as well. And investigations sometimes are necessary in those circumstances. So I just mentioned that just to say that it's not always grievance and disciplinaries that require investigations. They do crop up in other areas as well. So why are they important? Well, first and foremost, with a view to essentially avoiding tribunal claims. So, I put on there unfair dismissal or constructive dismissal, and you really can't underestimate the importance of a good investigation in minimising risk to the organisation. Fairness and reasonableness in both process and decision making are obligations which underpin all employment law. And so conducting a fair and balanced investigation is a key factor in discharging this duty. And also we need to consider the Aircas Code of Practice on disciplinary and grievance procedures, because in certain circumstances, failure to comply with this Aircas code can be taken into account following a successful tribunal claim, whereby compensation is uplifted by up to 25%, so potentially quite substantial. And so failure to follow the process, as I say, can lead to an uplift. And the Aircas code applies to grievances, and it applies to disciplinary dismissals, misconduct dismissals. And also, if you are looking to potentially dismiss somebody, you need to make sure you can rely on one of the 5 statutory fair reasons required for dismissal to ensure that the dismissal is fair. And where lines are blurred, for example, between performance and conduct, and a robust investigation into the issues at play here may help clarify, the actual reason for the dismissal. So what is an investigation? Well, essentially, as you probably know already, it's a fact-finding exercise where the idea is you collect all the relevant information on an issue or on a matter. Look at your internal policies and as a starting point, whether it's disciplinary policy, grievance policy, dignity at work policy, for example, to see if it sets guidelines on how investigations should be conducted within your organisation, and make sure you follow them. And the aim of the investigation really is to enable the employer to fully consider the matter, to then be able to make an informed decision on it. And as I said, investigations are key parts of any process, and it's important that they're done correctly, making decisions without completing a reasonable investigation or a fair investigation, or without indeed taking account of findings that have come from an investigation, can expose employers to potential claims. And as I said, the most common types of investigations are disciplinary and grievances, and for that reason, that's what I'm going to focus on this morning. So moving out to kind of the nuts and bolts, really, of carrying out an investigation. And I think really, for me, this key section is to try and give you some tips to assist you and some guidance if you are required to carry out an investigation, or you need to assist somebody with carrying out an investigation. So first and foremost, I've put up on this slide here some helpful resources. So I mentioned the Aircas code earlier, so I've put up the link there for the Aircas code, because that will sets out really what is required in disciplinaries and grievances in terms of the investigation. But Aircas guidance also has quite a lot of helpful information on how to conduct workplace investigations. And certainly when I conduct investigations, I always remind myself of the guidance under Aircas, because it is useful, it is practical. And for that reason, I've put it up there on the slide for you. And as I mentioned earlier as well, do look at your internal policies and procedures as well, particularly as they often have, timelines for completing investigations and holding meetings, or, for example, may include the right to be accompanied at investigation meetings. So you want to make sure that you do follow your policies. So the first question you need to ask is, well, what is actually being investigated? And the importance of properly thinking this through and setting out the terms of reference is really key here. So as I said, the very first thing to focus on is looking at what needs to be investigated. And it's vital that the purpose and the scope of the investigation is thought about and decided upon at the outset. Now, this may seem really obvious, but it's really crucial. And sometimes, investigations I've seen have been kind of launched into without a proper thinking of actually what are the issues, what's the matter we actually need to look at. And the other thing is, how much investigation, you need to think about how much needs to be investigated. So in terms of case law, it essentially just requires an investigation to be reasonable in the circumstances. I think when we look at, unfair dismissal law, etc., it all comes down to reasonableness in terms of the decisions that are made and the process that's followed. And it applies equally to the investigation. So first of all, you need to, for example, in a disciplinary, you would consider the allegations that have been made. And the grievance, you would look at the issues. Now, depending on the seriousness of the allegations or the seriousness of the issues that have been raised in the grievance, this is going to inform you as to how detailed and comprehensive the investigation needs to be. Because as a general rule of thumb, the more serious the issues or the effects on the employee involved, or the more serious the consequences on the employee, for example, potential gross misconduct dismissals, the more comprehensive that investigation should be. So the first thing that I do, and I would advise anybody to do, is to create a terms of reference. And this sets out essentially what the investigating officer needs to examine. It will include whether a recommendation is required. For example, in disciplinary investigations, you would often want a recommendation as to say whether this should be referred to a disciplinary hearing or not. The terms of reference should also set out how the findings should be presented, which normally, but not always, will be in a full investigation report. Terms of reference should also say who the findings should be reported to. So sometimes that may be HR, sometimes it could be a more senior individual within the organisation, or for example, in a grievance, it could be that you're reporting the findings to the person who's actually going to hear the grievance. And it should also set out who the main point of contact will be throughout. For example, that may be HR, and that could be for the purposes of facilitating meetings etc., and keeping updated in terms of timeframes for the investigation. Having a good solid terms of reference will ensure that the investigation is completed as swiftly as possible, that only relevant information is collected, and that disruption to the business is minimal. I personally refer back to the terms of reference frequently when I do investigations because they're a really valuable and important tool to keep me on track and to remind me actually what the purpose of the investigation is. And again, I know I've said this a couple of times already, but do check your policies and procedures and include applicable timescales in your terms of reference to ensure everything runs in accordance with your internal policies. Keep the employee who's affected by the investigation, whether it's a disciplinary or an employee who's raised a grievance, keep them updated on the anticipated length of the investigation, and of course do keep them updated if there are any shifts in that timetable as the investigation progresses. Sometimes new issues do arise during an investigation, and this may mean that the terms of reference may need to be changed or altered, or perhaps a further investigation is needed following the initial investigation. But wherever possible, any new issues should try to be incorporated into the existing investigation. So, a quick note on the investigating officer. And this is, again, another important first step. And it's important that whoever's chosen to be investigating officer is able to act fairly and objectively. So you need to consider whether the person you're thinking of appointing is appropriate. Are they already involved in the matter that needs to be investigated? Are they already closely connected with the issues or the people involved? Or is there potentially a conflict of interest? Because if there are any of those, then I would suggest that they wouldn't be appropriate to be the investigating officer. Consider whether the person who you want to choose has a good knowledge of conducting investigations, and whether they've had experience in or perhaps been trained in conducting investigations. But also, particularly with allegations of discrimination or bullying or harassment, it is also really useful if the person conducting the investigation has a knowledge of equalities, equal opportunities, and the law surrounding that, and the Equality Act. It is often because of the need for experience and for impartiality that often organisations will appoint an external investigating officer, and particularly where the issues to be investigated are complex or sensitive. And appointing an external investigator with necessary skill and experience is really important. And employers sometimes also struggle to find the resources internally to be able to dedicate, the window of time needed to be able to properly carry out the investigation comprehensively and, of course, swiftly. And it is also the case that an external investigator can also provide a level of independence, which is particularly important if the matter which needs investigating is highly sensitive, or perhaps if it involves senior employees. And also having external investigators can help preserve confidentiality as well. So it's for those reasons that often organisations will look to appoint an external investigating officer. A quick note, because I know that a number of the people who are watching this morning are in HR, and I think it's quite important, just to mention the role of HR in investigations. As I find that often internal investigators will rely quite heavily on HR and seek their guidance, particularly in relation to when they come to the recommendations and the likely outcome. And there's been a couple of cases looking at the role of HR in disciplinary investigations. And I put these on the slide. So the first case, Ramphel, this was an EAT decision, and it reminded us the extent to which HR can appropriately participate in disciplinary investigations and decisions. And in this case, the Employment Appeal Tribunal found that an employee had been unfairly dismissed after an investigation officer's report was found to be too heavily influenced by HR. And it's very clear from this case that HR's role should be limited to questions of law procedure and process, and they mustn't advise on culpability or the recommendations. And within a year later, there was a further EAT case of Johnsfield, and the EAT reinforced this decision. And here what happened is that the investigator had prepared their investigation report, but the final version of the investigation report had been significantly altered in light of HR and in-house legal advice. And the EAT agreed with the earlier case of Rampfel that HR's advice should be limited essentially to matters of law and procedure. So what happened is the EAT remitted this case back to a different employment tribunal to kind of consider the extent to which the investigation report had been amended and whether this should affect the fairness of the dismissal. But actually, what the tribunal found is that the draft report had been amended in light of the lawyer's advice that it shouldn't set out evaluative conclusions, but just be limited to say whether there was a prima facie case to answer. And for this reason, the tribunal found it's actually been reasonable for the employer to have their solicitor to advise the investigator on the content of the draft investigation report, given the scope for legal error here. So really, the advice was, in relation more to process in terms of your role as an investigator is to kind of establish what you think has happened and make recommendations. It's not to, for example, make a decision that the employee should be dismissed for gross misconduct. So because the lawyer's advice kind of related and HR's advice related to kind of more the process aspect of it and the remit of the investigation, the dismissal still found to be fair. But I think this is just an important reminder for you of the role of HR in investigations. The other thing that I wanted to just briefly touch on is kind of having an investigation plan. So the investigating officer does need an investigation plan. And this is kind of their first job once they've been appointed. And of course, the starting point will be the terms of reference that I've already chatted about. And from then on, the investigating officer should think, I'll put in their plan, what facts need to be established, and then what evidence will be necessary to establish those facts, and who may need to be called to an investigation meeting. The investigating officer will need to ensure that they are familiar with the relevant policies or procedures, and also needs to be, I would suggest, a timetable of action, so you have an idea of when you're going to be meeting with people, factor in time for reviewing the evidence, follow-up questions, and then obviously of course factor in time for preparing the investigation report at the end, if it is to be presented in a report. The interview process, just some kind of best practice, or just some tips really for the interview process. As I said, the investigating officer will need to decide who they think needs to be interviewed as part of the investigation. An interview should be arranged with reasonable notice. I personally prepare questions. I think really you should pre-prepare questions that you want to ask, but also not to script it so much that you feel that you can't go off piece, because often what happens is that you ask a question, lots of information comes back at you, and of course you need to ask the follow-up questions. But having kind of a key kind of guide of questions that you do need to ask, or areas around which you need to ask questions, is important so that you are prepared when you go into the interview. There is no statutory right to be accompanied at start that again. There's no statutory right to be accompanied at investigatory meetings, but Aircas suggests it might be beneficial. And also do check your policies, because I think, as I mentioned at the beginning, whilst there's no statutory right, I have seen a number of policies that do say that employees will be given the right to be accompanied at investigatory meetings, and often particularly for very nervous employees, or particularly where a grievance has raised very serious issues, and the person who's raised the grievance is nervous about attending. Often having a colleague with them does really help them and support them through that meeting. When you hold the investigatory meeting, you should always explain who's present, why they're present at the meeting, the role of the investigator. So explain why you're there and what your role is, i.e., what you're looking to investigate, and that you'll be producing your findings and where those findings will then go. Explain the purpose of the meeting, eyes to ask questions and establish facts around the issues. And also really important to ask the people who are attending that meeting to keep matters discussed confidential. And obviously the most serious the allegations or most sensitive the issues that you're investigating, the more important it is to keep those matters as confidential as possible. It's also important to ensure that accurate notes are taken at the meeting. Those notes will normally, will need to cover the points discussed as well as the answers obviously given. Often the notes become the interviewee's witness statements, which they'll be asked to sign. I always bring a note taker with me to any investigation meeting to ensure that the notes are as accurate as possible, not least because my my handwriting or my writing can't keep up with, or even if I was trying to type, it just wouldn't be able to keep up with what's being said. But also from experience, it's extremely hard to try to take notes as well as concentrate on the information you're receiving at the same time and to be thinking of those follow-up questions. So if it's all possible, do have a note taker present. In terms of evidence, it will normally consist of the agreed signed witness statements that have come out of the investigatory meetings. Will include any relevant written records and documents on the matter, any physical evidence. There may be some CCTV, for example, but that will need to be collated. Now, remember that the investigation just needs to be reasonable, and so there's no requirement to investigate every detail or accumulate vast amounts of evidence if it's not important or relevant to the issues. But do stick to what's reasonably likely to be important and relevant. And that's where it kind of links back to the terms of reference and why the terms of reference are so key, because they will keep you on track as to what's relevant to the issues that need to be looked into. So that was kind of a whistle-stop tour, I guess, of the process. And before I get to the investigation report point part of it, I'm going to look at briefly the importance of confidentiality and impartiality. So, as I said, wherever possible, confidentiality should be maintained. The investigating officer should consider how much detail witnesses will be required to know at the outset of the investigation, and of course should tell them that any information they receive as part of the investigation interview should be kept confidential. If a witness does breach this, then it's potentially a disciplinary matter, just so that you're aware. And it is often sometimes a bit of a fine line in deciding how much to tell the witness in the investigation interview, because you do have to be mindful of the need for confidentiality. So do seek advice on that if concerned. Employees may become aware that an investigation is taking place. If that happens, don't worry, it's often unavoidable, but it's more crucial that the details and the subject matter of the investigation should be kept confidential. You may find that you have some reluctant witnesses, more often than not in a disciplinary matter, and you'll need to find out really why the witness is reluctant to provide evidence, or to talk to you about the matter. And you've got to consider ways you can do to kind of allay their fears. Now, one fear may, of course, be that they're intimidated by the employee who's going to be investigated, so perhaps you can provide some reassurance there. You can consider witness oh dear, I'm not even going to try and say that word. You could try to consider having anonymous witness statements. I can see Louise smiling away at me there. But you need to think carefully about how this will impact upon the overall investigation and in particular reasonableness. And you've really got to balance that request for a witness to be anonymous against the accused employee's need to know the details of the evidence for and against them. And I think the difficulty is that even if you were to produce a witness statement that didn't have the employee's or the witness's name on it, more often than not, it's really easy to identify who's actually given that statement. In instances where the witness is genuinely in fear of physical violence, and of course steps should be taken and can be taken to protect their identity. But the reality really is there's no guarantee really that that they can be kept completely anonymous. And I think the other thing is that I'm often being asked in terms of, witness statements, who's going to see it? Can you guarantee that nobody else will see it apart from HR? But of course, if the matter did end up going to tribunal, then those witness statements are going to be disclosable. And so, and you also have to think about any potential subject access requests. So my advice is always, not to kind of provide cast iron guarantees that the witness statement won't be passed on to anybody else. The Aircas guidance on this is that anonymised statements should be avoided wherever possible, and only in exceptional circumstances where there's a genuine fear of reprisal. Now, I could spend quite a long session actually just talking about this, but I won't, because we've got a lot to cover this morning. But there is a case, an EAT case of Linford Cash and Carey Limited and Thompson, and they give some quite detailed guidance to help employers and tribunals balance the need for a fair hearing with the protection of witnesses. And so if anybody needs any guidance on that, then I suggest you kind of look at that case, or, obviously come and contact us for advice. It is a tricky area to navigate, and there are many issues to consider when you're faced with that issue. Impartiality, of course, it's really important that the investigating officer is impartial and maintains an open mind throughout the investigation. Conclusions and should not be predetermined. And the investigating officer's role is to present the evidence and conclusions of the investigation with any recommendations, and not make a decision as to what's actually going to happen next. Stick to the investigation plan and ensure that the questions that you're asking of witnesses are appropriate. Also, ask as many open questions as you can as to what did you see, what happened, rather than leading questions like, well, you saw him take money from the till, didn't you? All quite obvious things, I suppose, what I'm saying, but it is important to a reminder that, open questions, especially initially, are really important. However, closed questions can also be really useful as well to get a specific yes or no or definite answer from a witness. And also, if you have a witness who's like very overly talkative and keeps going off on a tangent, or if perhaps they're vague, then closed questions can really pin them down. A quick note on the investigation report. This slide kind of sets out the format really for you. So you would have an introduction, i.e., and that would normally, well, certainly in my reports, kind of sets out the terms of reference, i.e., what you've been asked to investigate. The summary of the process adopted, i.e., who you've spoken to, where you've got the evidence from, and a summary of the findings. So that would be a summary of the findings from all the evidence, the witnesses, the facts that you've been able to establish, the facts you haven't been able to establish, and any mitigating factors or any other factors that may be relevant for the person who's going to receive the report. The conclusion will make recommendations. Is further action necessary? Is a further investigation necessary? For example, where there's been relationship breakdowns, should counselling or mediation be considered? And often, sometimes you find that as a result of an investigation, you actually make recommendations in terms of policies or procedures being refreshed, because perhaps they're out of date or out of touch with the organisation. And the other thing the investigation report should have is an appendix, and that should include all the relevant documents the investigating officer has based their report on, and make sure that this is clearly indexed and referred to in the body of the report. After the investigating officer should be prepared to discuss the report in person with whoever they've sent it to. And as I said, the investigation may throw up some useful information with regards to policy or procedure review. And remember that the investigating officer is not the decision maker, even if they have been asked to make recommendations in their report. It's the person who hears the disciplinary hearing or the grievance hearing, whichever case it may be, who will be making the final decision. And of course, do retain the investigation reports for an appropriate period of time and in accordance with your data retention guidelines. Right, one more slide, and then I can stop sniffling and pass over to Louise. So a few potential pitfalls. The planning stage at the beginning on the investigation, as I'm sure you've heard me say, is incredibly important. Failing to scope out the investigation properly at the beginning is a common pitfall, can easily be avoided, and the scope of the matter should be clearly set out in the terms of reference. Similarly, if the investigator doesn't put a structured plan in place at the outset, the investigation isn't going to be structured or focused, and it may become confused or go off on a tangent or start considering irrelevant evidence. So planning is key. And of course, if it does go off on a tangent, that's when substantial delays can come into play as well. Ensure your investigator has the required competencies and experience in carrying out the investigation, particularly if it is going to be a complex one. Confidentiality. Remind witnesses of the need to keep matters discussed confidential. From experience, it becomes pretty clear quite early on in an interview if the witness has been prepped. I've had witnesses come with very comprehensive notes of what they needed to say, which are absolutely spot on as to the issues that I wanted to talk about, even though they hadn't been made aware of the issues I wanted to talk about beforehand. And also sometimes certain phrases will crop up, and the terminology used by one witness is exactly the same as the terminology used by another witness. And you think it's quite an unusual phrase. So there's been some talking going on there. But, you know, and that is important because you do end up, you have to, obviously, when you have different versions of events, you do have to consider, you know, which one essentially you believe, you prefer, you think is more reliable. Obviously, there's the other pitfall or issue of witnesses not wanting their evidence disclosed. I never give witnesses assurances of their evidence not being disclosed, and I explain the reasons why. We've already discussed the difficulties where a witness refuses to provide evidence unless on an anonymous basis. And essentially, you know, the first step there is to listen to their concerns and try to resolve them. And also, the other point I wanted to make, because there was a Freshfields case that came out really, really recently, in the past couple of months. Investigation reports prepared by law firms are not necessarily legally privileged, and so can be disclosable. So if a lawyer is engaged to conduct an investigation as a fact-finding exercise, as opposed to providing legal advice, then that investigation will not be legally privileged. And therefore, a good lawyer will be very mindful of that, particularly with any correspondence surrounding the investigation, which may be subsequently disclosable. So just a quick point on that. And also sometimes I see investigation reports that don't actually make recommendations, or potentially even worse, they just sit on the fence and they don't really give you a view as to actually what they think it may have happened. And you kind of look at it and think, well, where do we go from here? So as I said, the investigator doesn't make the decision in the grievance or disciplinary, but it should form an opinion as to what they believed has happened and make a distinction between the facts they've been able to establish and those they haven't been able to establish. Louise, do you think we should answer? I haven't looked at the questions, I've just seen them pop up. Do you think we should answer the questions before pass over to you, or should we deal with them at the end? I'm not sure whether they'd be relevant for both of us.
I think they're relevant for both of us, but I think we can deal with them now.
Okay.
If that helps.
Yeah, sure.
And then I'll carry on with my bit. So the first question is with regards to what's the view on recording interviews? And it says some of late have had to be completed via video, which of course we can record, which can avoid taking copious notes. Now, from my perspective, I don't have an issue with that, subject to the person that you're interviewing being made aware that that's the case and it's being recorded.
Yeah.
So that's my take on that.
Yeah, I completely agree with that. The only thing that I would add is that sometimes if people know they're being recorded, they may be even less, maybe even more nervous, or more reluctant in what they tell you. But you would soon be able to have that discussion with the interviewer as to whether they're comfortable or not. And
that's the key: having the interview with having the discussion with the person that you're interviewing to see what they're comfortable with, and that's from my perspective as well. Next one, does an employee need to acknowledge a manager's file note, which could be used at a later date in grievance or disciplinary proceedings?
I'm not sure I understand the question.
So my understanding is that once the interview has taken place, and you'll have to correct me if I'm wrong, Vanessa, that those notes are passed back to the person that you've spoken to make sure that they're happy that what you've recorded is correct.
Yes.
So I think the answer to that one is yes, in essence.
Unless it's a part of a disciplinary procedure, where sometimes employers have kind of like, rather than going straight into the first written warning, second, final written warning dismissal, they have something called like informal file notes or notes of, or letters of concern, where then perhaps that's what it means. I don't think an employee needs to necessarily acknowledge that they received a file note or a letter of concern. You just need to make sure that they've received it, because that would be relevant. Potentially, it is going to, of course, be relevant evidence if it covers the subject matter of the grievance or the disciplinary.
So yes, come back. And can a witness provide a statement anonymously as part of the investigation and only go on record if the matter in case of a dismissal is then taken to, and it's then cut off the bottom bit. I mean, my view would be that we'd advise against that, in that you confirm at the start, but then I think it's very much fact dependent upon what's the reason for them wanting anonymity, and that word at the time.
Yeah, that word. Oh, good. You can't say it either. Brilliant.
That word.
Yeah. If we somebody to type it now, then we have to say it. That would be great, wouldn't it? I think also you've got to also think about it in the context of the fairness of the potential dismissal as well, and if having an anonymised statement actually potentially fares. I can't say any words. Potentially affects the fairness of the dismissal and the process that you're following, because of course it is really important that the employee facing disciplinary action or dismissal knows the case against them. Yeah. So anonymous statements are a last resort, really.
No, I agree.
And as I said, it's also unfortunately the case that even if statements are produced anonymously, often you can actually just work out who they've come from. Shall we move over to you?
Yeah, and I mean, the reason I wanted to cover off those questions is because actually everything that Vanessa has just said basically applies also to when you're investigating accidents, and it seemed easier to sort of tie off all those issues, because I'm going to go off on a different tangent with regards to what to think about when you've had an accident, an illness reported, or an incident at work, and it's specifically with regards to the practicalities of dealing with those types of investigation. But all the information that Vanessa's just given you applies exactly the same way. So in terms of accident investigations, from my perspective, from a health and safety perspective, what's the purpose of those? Well, the same as what sort of Vanessa said for her employment related investigations. The main thing, ascertain what's the cause of the accident or the incident. And often the investigations that we are producing when we're investigating is to prevent a reoccurrence and to learn from mistakes, and to perhaps refine any working practices and procedures, and to basically give your employees confidence that what's happening in the workplace is continually being looked at. And in particular, where you've got a serious accident or incident that's taken place, I think it would be quite remiss of an employer not to investigate it, not to look into the matter. I mean, it may well be that accident is just one of those things, and accidents do happen. It may be the fault of the employee. But I think if you don't undertake an investigation and don't look at the causes and don't look at all those factors, I think that you might end up with issues of confidence from your employees for not taking what's happened seriously. So mainly to investigate what's the cause of the accident and whether or not you can learn from it. You also have duties under the Health and Safety at Work Act 1974 and the Riddle 2013 regulations, which is the reporting of incidents and diseases and dangerous occurrences. And you have a requirement in some cases to actually report the accident. To some extent, therefore, you have a duty to make some kind of investigation into the matter. I'll quickly touch on Riddle reporting in terms of what accidents need to be reported. Riddle reporting is where you have an accident or an incident that's taken place, or a near miss, and you actually have to report that to the health and safety executive because it's happened in the workplace. Fatal accidents, whether it's one of your employees or whether it's someone that's visiting your premises, if the incident involves a serious injury, and there's a long list of what injuries that might apply to. It could involve broken bones, crushing injuries, scalding injuries, or exposure to chemicals. And any injury or incident that results in an employee being off work for around 7 days. And I also believe also with regards to any visitor who may be off work for a period of 3 days, you also need to report them to Riddle if that accident has taken place on your premises. You should report as soon as possible, and within 10 days, a formal Riddle report should be lodged if it's an incident or an accident that is Riddle reportable. So also you're going to have to do some kind of investigation to make that report to the HSE accordingly. Also, in terms of investigations, the benefit of doing them is that you can perhaps preempt a personal injury claim. And I'll go on to deal with how crucial undertaking the investigations at an early stage is, and doing those investigations properly, because of the impact that it can have if you're likely to have litigation or a claim being brought against you in the future. Having undertaken an investigation at the early stages can often mean that you can make decisions quickly with regards to whether or not that case or that claim is to be defended, or whether you've got everything together already to be able to say, I'm really sorry, we've done nothing wrong, we've complied with our practices and procedures. And I'll go on further to talk about that. So it's to also preempt a personal injury claim or deal with potential litigation, and to provide assistance to your insurer if a claim is submitted and you're able to say, here's our investigation, here's all the evidence that we gathered in support, the witness evidence, the documentary evidence, then you're able to assist your insurer to make decisions quickly and to deal with the claim accordingly. And as I've already referred to, employee morale, it's so important that if a serious incident takes place, you're seen as the employer to look into what happened and whether we can do anything at all to prevent that incident or accident happening again. So in terms of what incidents, what accidents should in fact be investigated, and also it ties into what the depth of any investigation may be, it's very much case sensitive and fact sensitive in terms of what actually happened, what injuries resulted, and what the consequences might be. So for example, if someone sustains a paper cut, I don't think you really need to be investigating that, to be honest. If you've got someone who's got serious injuries, or there's been an assault in the workplace, or perhaps it's a matter of sensitivity, then you need to think about what level of investigation you might want to undertake. It might be that it's just limited to getting a few documents together, speaking to 1 or 2 people and just doing a report, or you might be looking to undertake a much further and much more extensive investigation, and in particular where there's sensitive issues to be discussed, or perhaps where there's reputational damage to the company if that investigation isn't done properly and all the information is collected and it's all there to back up whatever recommendations or whatever situation it is that you then need to face at a later date. In terms of who should undertake the investigation, what Vanessa says again chimes completely with regards to accidents and incidents in the workplace. It might be that it's an investigation, a quick and simple one that perhaps HR can deal with, or if you have a nominated health and safety person that they can look into, or because of perhaps any sensitivities, any reputational concerns, or the gravity or the complexity of that investigation and that accident, you might be looking to want to appoint an external investigator to come in to make sure that any investigation that is undertaken is complete, it's detailed, it's thorough, so that it covers off any issues that you're likely to face in the future. But it will be case sensitive. The more complex the accident and the injuries, in all likelihood, the more in-depth and more extensive the investigation is likely to be required. And then when should that take place? Well, in terms of accidents and incidents at work, if it's a perhaps less serious injury, it's perhaps not reported to the HSE, or the police aren't involved, then you can do that investigation yourself as the employer as soon as possible, really. If it's a case involving perhaps a fatal accident, it may well be the police are involved or the health and safety executive are involved. And at that point, you need to let them undertake their investigation first, assist them with their inquiries, obtain the documents that they're perhaps going to be requesting, and give them access to the witnesses that they're going to want to speak to. And once their inquiry has been undertaken, I still think it's important that as the employer, you undertake your own investigation into the matter, aside from anything that the police or the health and safety executive do. And I would, rather than tread on the toes of the authorities that are perhaps dealing with their official investigation, wait for that to be concluded. And then as soon as you can, conduct your own investigation into the matter. Again, for all the reasons that I previously cited with regards to getting to the cause of the accident, whether you can learn anything, whether any policies or procedures need to be refined, or whatever needs to happen. So in terms of an accident actually happening in the workplace, what's the first step? An incident's happened. Well, obviously, first of all, get the necessary medical or emergency assistance on board and get that person help. Secure the scene and perhaps even stop work, again, depending upon what's happened. A serious fatal accident or really serious crushing injury or anything like that at work, then we'd be saying stop work, get the employees out of the way. And when it's appropriate, when first aid has been administered or the emergency services have left, then perhaps you want to be taking photographs at the scene and starting to take notes of what's happened, and taking the names and details of persons and any witnesses who are involved who might be able to help out. So they're the first steps once an accident's happened. Also, initially report it to the manager, line manager, anyone. If you've got a dedicated person responsible for health and safety, make sure they're on board, get them down to the scene of the accident and take as much information as possible, if you're able to, provided the authorities aren't involved at that stage, and start getting together all of your information that you need. Report it to the health and safety executive if appropriate, as I've already touched on, if you need to make that formal Riddle report, and make sure that you put a report of the incident in your accident report book. So that's once an accident's happened, they're the first steps you should be thinking about. And after that, we're then looking at going into your evidence gathering. And when you're looking at what to do in terms of preparing an investigation report once an accident or an incident's happened on your working premises, that evidence gathering is crucial to the outcome of the investigation, and it could potentially be crucial in terms of the outcome of any potential claims in the future. And I can't state enough how important it is to get that information as soon as possible. As time goes on, documents might be lost, people's memories fade, people leave your employment, and therefore getting hold of them and getting the information that you might need in the future may be more difficult. From a personal injury claims perspective, cases are often won or lost dependent upon that evidence, dependent upon those documents. I have a case at the moment where we're looking to probably do a deal on a settlement because the defendant in that case, with my claimant hat on, has lovely evidence of their practices and procedures that were in place. But what they don't have is evidence from witnesses saying those practices and procedures were in place at the time of this incident. And without that evidence, they can't prove that what happened, the practices and procedures were followed, and that it then would have affected my client's injuries and the accident that happened. So they're now looking to settle the claim because when we submitted that claim, they didn't then do their investigation. They didn't then gather the witness evidence they needed to refute the claim that I'm now making. And as a result of that, their defence will fail. Equally, investigations that I've undertaken where we've been notified of the accident, the police and the HSE have done their bit, and we've then gone in to take those witness statements there and then. Their memories are fresh, it's contemporaneous, and therefore over time their memories aren't impacted by perhaps other people talking about what's happened as time has gone on. That witness evidence that we got there and then has enabled a client to say, I'm sorry, I'm not dealing with any claim for personal injury, this was nothing to do with us, because we were able to gather that information at the time, which will then have an impact upon any potential insurance claims or any potential even health and safety prosecution in the future. So when you're looking at the evidence gathering itself, it's all about the facts. It's all about what happened, when it happened, who it happened to, how it happened, and where it happened. You want to be building up a picture of a chain of events that led up to the accident taking place, and then the aftermath as well. And you need to be looking at your practices and procedures in particular to find out, were they followed? Are they sufficient? Do your practices and procedures need changing off the back of this accident? And that investigation report and all that evidence gathering that you should be doing should flow back to your practices and procedures and your policies to make sure that they were complied with at the time. And therefore, whatever happened, perhaps that isn't an accident that could have been avoided, it's human error, but you had in place all the relevant procedures, and your evidence can back that up, and your witness evidence and your documentary evidence can back up that you did all that was reasonable, or perhaps not. Perhaps you do need to tinker with something, or you need to change your views. So there's two parts to gathering evidence, or there's two parts to evidence as it stands. You have the documents, and I've highlighted some of the most common ones that we would be requesting when we're investigating accidents in the workplace. It's photographs and maps and plans. The accident book entry is also really useful, because that, as I've said, should be one of the first things to be completed, and that will be a contemporaneous record of what happened, and that's really important. Any records of any previous incidents, any method statements or policies, get your health and safety manual together. If it involves any equipment, look at any maintenance records for that equipment, any details of what the equipment involves. Training records of that person who's involved in the accident is also really important. We have a number of cases that we're running at the moment where the issue just comes down to the fact that the claimant didn't have sufficient training to do what he was doing, and he'll in all likelihood succeed with those cases. And also any correspondence with the health and safety executive if it is a Riddle reportable case. So that's the kind of documentary evidence that you're going to be looking to gather. And once you've got that evidence, what your witness evidence does then fleshes out those documents to some extent. Because when you're taking that witness evidence with regards to an accident or incident in the workplace, you're asking those witnesses, what happened? What's your relationship to the person involved? What did you see? What's your background? What's your knowledge of the practices and procedures? And what training did you have? What would you have done? It's really difficult often for witnesses not to give their opinion as to what the cause of the incident was. Now, ideally, witness evidence should just be limited to the facts of what they knew, what happened, what they saw, and what their knowledge was, and that's it. But often I do ask witnesses, what's your view? Did we do something wrong? Could we have done something better? Should we have provided training on this? Should we have provided different personal protective equipment? What could we have done? Because it's also useful as an investigating officer to get those opinions and get those views from people on the ground. Although, as I said, when it comes down to it, the difficulty is when you're finalising witness statements for the purposes of court proceedings, ideally they're meant to be just limited to facts. But it is useful to get people's opinions, and those employees in particular who are involved, as to what happened and what their views are and what perhaps you could do better if that is the case. So you've gathered together your documentary evidence, and you've gathered together your witness evidence. And then the idea is that you approach the investigation report very methodically. And it covers, again, exactly what Vanessa said in terms of how she approaches her employment-related investigation reports. It's to some extent exactly the same. What are the facts of the case? What happened? Why did it happen? Be thorough, look at the documents. This is the policy. These are the practices and procedures. Were they followed? Did we deviate from them? And if we did deviate from those practices and policies, why? Is this a regular occurrence? And it's thinking about perhaps where there's gaps also, in that whereas the witness statements should flesh out perhaps the documentary evidence, and they should refer back to your policies and procedures and tie in with those, it might be that there's further questions that then flow with regards to those witnesses' knowledge. And you want to make sure that you follow that paper trail, you follow those questions that then roll off the back of the documents. So when it then comes to drafting your report, you have a clear report detailing exactly what happened and why, and where you are making recommendations, you can explain why off the back of those documents and off the back of that witness evidence gathered. And then you've got your conclusion. at the end, which should be the recommendations, if any. Perhaps you need to think about providing different PPE. Perhaps you need to be thinking about amending your policies to prevent a reoccurrence. So then in terms of once that investigation report is completed, that should provide recommendations, and the action plan is very much dependent upon what the cause of the accident and the risk of reoccurrence is. It might be that this incident or accident that happened was such a low risk that your recommendations are, we don't change anything. We don't have the resources to do so, that it's such a low risk. This was such an infrequent or, never seen before event that it doesn't warrant changing any of our risk assessments or our practices and procedures. Or perhaps we're in a situation that this incident had happened and there were records of previous incidents and we didn't do anything about it. And we therefore now need to make sure that we amend our practices and procedures so that this doesn't happen again. Again, revisit your risk assessments and controls. If it's the case that your risk assessments haven't been looked at for a number of years, revisit them, make sure they're up to date, make sure that you're thinking about all the incidents and all the accidents that perhaps have happened that haven't been previously taken into account so that you're covered off in the future. If it's the case that you've got an employee that perhaps just hasn't followed his training, hasn't followed the practice and procedures, do you need to think about disciplinary action? Or is it the case that you can provide them with further and better training so to prevent a recurrence in the future? I've already touched upon whether or not you want to think about alternative equipment or personal protective equipment. Whatever conclusions you do reach, it's crucial that you keep that report, that evidence together in one place, and that it's kept for a certain period of time. As some of you are probably aware, in terms of personal injury claims, a claimant has 3 years in which to issue court proceedings in which to intimate a claim to either their employer or the insurance company. So it's so important that once you've done that investigation and you've got all that evidence together, you keep it safe, and you keep it safe for quite a few years, so that if in the future a claim is made, you've got it all there. And it's often the case that having undertaken a thorough, comprehensive investigation right at the start, after in particular a serious accident has taken place, you've got everything together. You can submit that to your insurer and say, you can defend this case. We've done everything we should have done. Look, here's the evidence. Here's our witness evidence. Here's our policies. It's all there. And it's so important that you keep it safe for a number of years, so that if it is required, then you've got it to hand. And also, it's worth mentioning with regards to in the insurance policies that your employer's liability insurance policies in the background, once an accident has taken place, I would recommend in any event, just notify the insurer that it's taken place. Whether or not a claim is brought in the future, at least you've notified them there and then. And if need be, as I said, you've got all your evidence to hand. So that's kind of all I wanted to say, because as I said, a lot of stuff that Vanessa covered also applies to my area of accident investigation. The key point that I would like to make as a result of certainly accidents in the workplace is to ensure that you undertake that investigation as soon as possible. Make sure you've got your witness evidence. And if you're in the case where, or if you're in a situation where perhaps those witnesses are going to move on, if you can get their new addresses or anything along those lines, to make sure you keep in contact just in case, that's really helpful. Cases of personal injury are often won or lost dependent upon the witness evidence that's presented to a court. If you don't have that witness evidence, or if you're not able to call that witness, then your claim may fail. You may not be able to defend any potential claim in the future. So it's important you gather the witness evidence, the documentary evidence, you undertake that report, and you keep it safe and secure. I think that's all I had to say, unless there's anything else at all you wanted to add.
No.
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 No, thank you. No, I mean, as I said, like this topic, we could do like a whole half a day or day training session on conducting investigations step by step, couldn't we? But yeah, so it'd be really interesting to know actually feedback on this morning's webinar, because obviously it's not just a small topic we picked, but something that hopefully we've managed to give you some useful information within an hour on, and hopefully it's given you some guidance. And if anybody's got any other questions or they want to contact us directly, then of course do. But no, thanks, Louise, and thank you to everybody for attending. Quick question. Oh, there's a question.
Yeah, sorry, yeah.
What, in your opinion, would be a reasonable timeline for an investigation? Oh, this is a lawyer answer. It really depends on the subject matter being investigated. Everybody will, before people sign off, actually, you will get a copy of the notes afterwards. Not a problem.
I think the only thing I'd add to that, in terms of how long it takes, it's often dependent also upon when you can speak to the witnesses.
Yeah,
when you can get the documents, who's available, where and when.
I think particularly if you've got an employee who's suspended pending disciplinary action, you want to kind of minimise that and carry out an investigation as quickly as possible. And I would have thought, within a couple of weeks. Yeah. But if it's, for example, if it's a grievance that's been raised with really serious issues and it needs a number of interviews and such forth, and then investigations can run 4 to 6 weeks.
Yeah.
And that is still a reasonable time frame. Yeah. So you've got to look at the scope of the investigation, whether you've got any employees who are currently, suspended, and the impact on them. It just comes down to what would be reasonable. And obviously, if there are delays that could be avoided, then that's when the timeline is starting to drag on too long, really.
Yeah. No, it's the same from an accident perspective, in that often I'm following a paper trail. And I'll get a load of information in, and then that information will point me in another direction to get a load more information and take more. And you could be looking at a couple of weeks to 2 or 3 months, depending upon the extent of it.
Yes, it is. And also when you're asking the witnesses to, of course, sign their witness statements, that can take, from experience, quite a bit of nudging to get the notes back and chasing. But as long as the investigating officer is doing everything they can to keep things moving and do things in a timely fashion, then you're absolutely fine. And of course, just keep the people who are affected, primarily affected, whether it's the person who's raised a grievance, the person who's subject to the disciplinary, potentially informed of the timeline and any delays. But thank you for everybody for your thank yous, and thank you for the questions, and lovely to see your names up on our list of attendees, and we'll see you next month.
Okay.
Thank you.
Thank you.